Welcome. My name's Edward Denehan, and thank you for signing up to and indeed now attending the short webinar that I'm going to present this afternoon. As you know, the subject matter of today's webinar is generally dilapidations, more specifically tenants repairing obligations, compliance and breaches. It's the first in a series of 3 webinars that I'm going to present this month, November and December of 2021, all on the subject of dilapidations. The second, which is on the 11th of November at 3 o'clock, is the landlord's remedies for breach of tenants repairing obligations at the end of the term. And the third, which is going to take place on the 9th of December 2021, is litigation and litigating a dilapidations claim. I believe that all 3 webinars stand alone, but for the full Denehan effect, if I can put it like that, I do invite you to come along to the other 2 webinars as well. They'll be about 3 o'clock, 1 hour, and the same, a very reasonable price, namely nothing. I've chosen dilapidations as a subject for this series of webinars for reasons that may be obvious to you, that there are lots of commercial tenants who are giving up or thinking of giving up space. And frequently, the issue of dilapidations on giving up space is one that's not always first considered. There might be a reverse premium to break a lease, as we have in our chambers lease and so on and so forth, but one forgets about the dilapidation. So I thought it was the ripe time and the right time to consider that issue, namely dilapidations. The first paper, the paper that I'm going to speak to today, it concerns certain preliminary matters about the obligations and compliance and so on and so forth. As I say, the nitty-gritty of litigating and damages will be dealt with in the following webinars. The process I adopt for the webinars is this, that I'll speak for an hour. I have produced 3 written papers that address the 3 elements of today's webinar. They will be distributed to the delegates after the webinar is completed. I'm not suggesting this afternoon, but in the next short period, together with the slides. And indeed, I think this time, for the first time, the webinar has been recorded. So those of you who want a recording for whatever purpose, that can be requested from my clerks and so on and so forth. Experience tells me that dealing with questions during the course of an hour's webinar doesn't really work, mainly because of my lack of knowledge of how Zoom and technology works. But I'm very happy to address any questions you might have arising out of the subject matter of the webinar. If you send me an email, my email address is at the bottom of the papers and will be on my website. It's my name at 9stonebuildings.com. I can't answer specifics about any particular case you have, but general points arising out, I'm very happy to converse and give you such thoughts as I have on the subject matter of your question. So with that rather wordy introduction, I'll turn to the first paper, and I'm going to speak about the tenant's obligations in respect of repairs, improvements, and inherent defects. Now, of course, I've titled the paper Tenant's Obligations, but of course, the obligations are often comparable from the landlord's perspective. It's just the covenantor, or the person who promises to do something, carry out works, who we're concerned with. There's not an exact copy on either side of the equation, but much of what I say applies equally to landlord's obligations. So I ask you to bear that in mind. And of course, there's often an unhelpful overlap between what constitutes a repair, an improvement, and works to deal with, to put it neutrally, inherent defects. The first point that's to be made, of course, that the obligation of the tenants to repair is first defined by the written instrument, assuming there is one, between the landlord and the tenant. And therefore, in the first instance, the obligation is defined by the words the parties have used. And therefore, in the same way with any contract, and the lease is nothing if it's not a contract, the starting point is to properly construe the lease. The scope of this paper doesn't allow me to bore you with the rules of construction. We're all fairly familiar with them, but the starting point and the beginning, the end point, as far as I'm concerned, for present purposes, is what Lord Hoffman said in the Investors' Compensation Scheme, that the interpretation of a lease, a written instrument, is the ascertainment of the meaning which the instrument could convey to a reasonable person, having all the relevant background knowledge which would reasonably have been available to the parties in the situation in which they were at the date of the contract. So that's very familiar law. The learned judge went on to explain in that case, I haven't put it on a slide, that the relevant background includes absolutely anything which would have affected the way in which the language of the instrument would have been understood by the reasonable person. So it's fairly open shop. What is not admissible as an aid to construction are previous negotiations, previous drafts of leases, and so on and so forth. That is not admissible. One issue that does arise in this context, and it's been identified by the learned authors of Dowding and Reynolds on their book Dilapidations, the Modern Law and Practice, a work which I can't praise enough as a great aid for practitioners. It's both thorough, academic, but really practical as well. Any problem that one has with dilapidations, the answer is buried in Dowding and Reynolds and some place, 6th edition now. So I do recommend it to you. But they've identified a particularity of drafting style that arises in repairing obligation, and it's been described, I think it was again by Lord Hoffman in Norwich Union case, the torrential style of drafting. And I put on the slide at the moment what that is. It's well and sufficiently and substantially to repair, uphold, sustain, maintain, glaze, pave, amend, and so on and so forth, the subject matter of the covenant. It could well have said well and sufficiently repair the said premises, but we have all those other adjectives in there as well. Such torrential style is often found in restrictive covenants, in conveyances, and so on and so forth. And I must confess that I'm guilty of that when I turn my hand to drafting. One starts with the general point and or the general subject matter, and then adds more and more particulars about that. The problem is that the cases don't wholly speak with one voice on how one treats these torrential clauses. The starting point is that the effect must be given to all the words used in a contract. So when the contract talks of sustain, uphold, amend, meaning must be given to each of those words, and they must mean something different to repair. Otherwise, there'd be no point in using them. The Century Projects case, which I've highlighted on the slide, supports that proposition. But then again, in the Norwich Union case, again, it was Lord Hoffman who simply said that that's what draftsmen frequently do. They use many words, either because it's traditional to do so, or out of sense of caution, so that nothing which could conceivably fall within the general concept, that is repair, which they have in mind should be left out. Then on the other hand, in the well-known case of Credit Suisse and Bigas nominees, we'll come across this case several times this afternoon. The judge there, Mr. Justice Lindsay, said if the covenant says repair and keep in good condition, then the obligation to keep in good condition means something different to repair, and effect must be given to that. I've set out the relevant sections from the judgment of Mr. Justice Lindsay in the paper. Dowding and Reynolds suggests that the correct approach, supported by the Credit Suisse case, is that effect must be given to each part of the repairing covenant. So condition means something different to repair, which means something different to renew. but the good sense of the agreement reflected in the covenant must be found, which is all wonderfully neat and tidy when stated in a textbook, or indeed even the judgments of the judges. But it's often hard to actually discover what the good sense is reflected in the agreement. In the Credit Suisse case, we'll talk about the facts of that a little later, it was no great leap for the judge to find that the obligation to keep in good condition, or words to that effect, meant something different to the obligation to repair. So the starting point will always be that one has to give meaning to all the elements that are used in a repairing covenant. So getting to the meat of it, putting aside construction, I started by asking the question, what is a want of repair? The case I find most useful about this, because factually it's straightforward and it makes the point very well, is the Post Office and Aquarius Properties case decided in 1987, which again, the citation I put on the screen, but dealt with more fully in the notes, contained an office block in the city. The tenant was the post office, and the underlease that the post office held required the tenant to keep in good and substantial repair the demised premises and every part thereof. So it was only to repair, and it had to be good and it had to be substantial. The block periodically flooded. This occurred when the local water table rose. The water entered the basement because there was a defect in the structure of the basement, which had existed since the day the building was erected. By the date of the litigation, the defect hadn't got any worse, but was in the same condition as it was when the building was built. In that case, one of the judges, this is a Court of Appeal decision, one of the judges, Lord Justice Ralph Gibson, said, apart from permitting water to enter, which disappeared when the water table dropped, leaving the basement dry for the last 2 years, no damage to any part of the building is shown to have been caused by the defect. The question then was whether the building was out of good and substantial repair for the purposes of the covenant. If it was, then the post office had to make good. If it wasn't, then they didn't. The Court of Appeal held that there was no want of repair, and therefore the tenant, the post office, wasn't obliged to carry out any works. And in so deciding, the Court of Appeal in the post office case relied upon the Quick against Taff Ely Borough Council case, where Lord Justice Lawton said, as I quote, as a matter of ordinary English, uses of English, that which requires repair is in a condition worse than it was at some earlier time. Now, going back to the facts of the post office case, the structure of the building, the basement, was in the same condition as it was when it was constructed and hadn't deteriorated at all. I suppose, save saying that it got wet when the water table rose, there was no change whatsoever. And Lord Justice Dillon said much the same in the same case. So the important point, and once it's in one's mind, I think it's helpful because it clarifies matters. The key to understanding the obligation to repair is the proposition that that which is to be repaired, the subject matter of the covenant, is in a physical condition worse than it was at some earlier time. There must be some deterioration in that physical condition for there to be want of repair. The question then arises is, what is the relevant earlier time? Well, the earlier relevant time is when the subject matter of the obligation to repair was constructed, not, if different, the date of the lease. And one can see certain issues about that. So if one takes old premises, there might immediately become an obligation on the part of the tenant to carry out works because at the date of the lease, the physical condition of the premises is worse than it was when the building was constructed. The Gibson Investments case, a decision of Mr. Justice Neuberger, as he then was, supports that proposition. The justification for taking the date of construction is that what constitutes disrepair is to be viewed objectively, and whether or not there's been a deterioration from can't be decided upon, or can't depend, forgive me, upon the accident of when the lease was granted. And as I say, this is consistent with the other general proposition, namely that if a tenant takes a lease subject to a general covenant to repair and the premises are out of repair, there's an immediate obligation on the tenant to make good, even though the want of repair, as it were, arose during a time when the tenant had no interest in the building. An important distinction to have in mind is between repair and function. A failure of function is not of itself a want of repair. And the Stent case, and Stent and Monmouth is the case that supports that proposition. Again, another Court of Appeal case. In that case, the front door of a house failed to keep out the rain. The door itself was not damaged. It had not deteriorated from previous physical condition. It simply didn't function well as a door intended to keep out the rain and the wind, and no doubt the cold. The local authority were under an obligation to keep the structure and exterior of the house, this is residential, in repair, and it contended that the physical condition of the door had not deteriorated, and therefore they were not obliged to repair. The Court of Appeal agreed with that. I've set out a section from Lord Justice Stocker's judgment in the notes that accompany this talk. I always like to mention my own cases. A few years ago, I was instructed on behalf of the landlord of a riverside block of flats on Wapping High Street. He looked over Wapping High Street on one side and the River Thames on another, and it's quite upmarket. It had been a warehouse back in the day, and it had been converted into luxury apartments, not flats, of course. And the landlord covenanted with the tenant to repair certain reserved property, which included the external windows and walls. They were quite large windows because the windows had been carved out of what had been the apertures where goods had been lifted in and out of the warehouse back in the day. The tenant of the penthouse, an American oilman, complained that water and wind entered through the windows and the double doors, which fill these large apertures, and therefore the quote, the doors and windows were in a state of disrepair. We commissioned an expert the tenant himself commissioned an expert and said that was a result of the windows and the doors opening inward rather than outward. Apparently that's, and he couldn't point to any deterioration in the physical condition of the windows and of the doors, which resulted in water entering the flat. On the basis of the post office case and the Quick case and the Stent case, I took the point in our defence that there was no want of repair at all. These doors and windows simply didn't function very well as doors and windows. At an interim hearing, the judge volunteered an early neutral evaluation and told the landlord, sorry, forgive me, the tenant, that he was going to lose, and the claim was discontinued. I would suggest that that was a crass error on behalf of the tenants. I'm not blaming his or their lawyers. They had a difficult client, but there's a stark example of failure of function is not the same thing as failure is not the same as want of repairs. The converse of that is also does not necessarily follow. The fact that the subject matter of the covenant to repair does function doesn't mean it's in repair. It can be out of repair. In the Gibson investment case, a case I've mentioned earlier on, there were cracks in the exterior walls of a building. There was no suggestion, no evidence, it wasn't alleged that water entered the building or wind entered the building or otherwise failed to operate as protective external walls. The external walls played no structural role in terms of support, and nothing that the walls were doing was compromised by the cracking. Nevertheless, it was common ground. The exterior walls were out of repair because they were cracked. A number of cases have addressed, believe it or not, the issue of corrosion and rusting, usually with crittle windows. Applying the principles that I've just stumbled through, rusting windows and water tanks are out of repair because they've deteriorated from a previous physical condition, even if the tank holds the water and the windows keep out the wind and the rain. Accordingly, corrosion or rusting will generally amount to a want of disrepair. Forgive me. The cause of the physical deterioration is prima facie irrelevant. Accidents, parsimony, idleness, it doesn't matter. If there is damage to the subject matter of the covenantor has to repair. Anticipated future deterioration, it's not necessary for the covenantor, the tenant in our case, if you will, to anticipate what might happen in the future if at the present time the subject matter of the covenant is in repair. So if the tenant is advised that in 6 months' time, a year's time, the flat roof will fail, but at the moment is in repair, then there is no obligation on the tenant to anticipate the failure that will take place in a year. Pause there. A sensible covenantor will anticipate or will make provision to ensure that when the subject matter of the covenant is to fail, they are ready to go with the necessary works. What about the subject matter is partly out of repair and partly in repair? The classic example of that is flat roofs, be they on domestic premises or commercial premises. They fail, they crack, holes appear, and so on and so forth. So some parts of the roof are out of repair and some parts are not out of repair. That's exactly the position in the Postel Properties and Boots the Chemist that involve the very large shopping centre at Milton Keynes, the Milton Keynes Central, I think it's called, or something of that nature. And an issue there came as to whether the cost of replacing the entire roof could be recovered through the tenant, from the tenants through the service charge. That's often the dynamic of these disputes. And as I've said on the screen, it's a matter of common sense, having regard to the best practice and to economics. And what that means is not how much is it going to cost now, but how much does the total replacement, how much will that cost compared with the continuing patching going on, perhaps from month to month, if not from month to month, then from year to year. And in Mr. Justice Ian Kennedy, who was a judge in that case, set out at some length that the landlord surveyor had walked the roof and she had formed a professional opinion that the most economic, common sense and practical way to deal with the deterioration of the flat roof was to replace the whole wretched thing rather than to patch. I set out the substance of his observations in the notes. I've touched upon this earlier on, an obligation to keep in good condition. Is that something different to repair? Coming back to the basic principle of construction that we touched upon earlier on, I would suggest that it does. The Credit Suisse case is the best example I can think of that. You may or may not be familiar with the building that's the subject matter of that case. It's on St. James's. It's on the corner of St. James's and that road that leads up to Duke's Hotel. It's called the rocket ship because it looks like a rocket ship. It's got metal cones and so on and so forth. It's residential and commercial, and whilst it's been around a few years now, but that 1994, it's still a fairly interesting new building, or let's say interesting, I mean mocked. The problem was that the external metal work, as it were, was not out of repair in the sense that it hadn't deteriorated from a previous physical condition, but water got in. So the claim by the tenants, I believe it was, concentrated on good condition. and having regard to the nature of the building, high-end offices, high-end residential in a rather smart part of town, it couldn't be said that water entering the building or building where water entered was a building in good condition, and therefore the covenantor was obliged to make good the defect, if you will, or the circumstances which gave rise to the water entering the building. And there are a number of other authorities that support that proposition, which I refer to in the notes. So that's a basic understanding of what constitutes repair. Moving on now to what improvements. The general proposition, supported by a fairly recent Court of Appeal, it doesn't seem that long ago that this case was decided, that the obligation of a covenantor under a general covenant to repair doesn't impose an obligation to improve the subject matter of the covenant. However, there is sometimes no obvious line between what a repair is and an improvement. I pause there to mention again the London Borough of Hounslow and Waller. It's very interesting and very clear judgment in the Court of Appeal of Lord Justice Lewison, who knows a bit about this sort of thing, where many of the general propositions and points that I deal with or attempt to deal with this afternoon are set out in a very palatable form. And we all like judges in the Court of Appeal setting out little lists of propositions which described, as in that case, is uncontroversial. So I do recommend Waller as a case that one could take some time to read. Very straightforward. So that's the general proposition. So what's the test? Well, in a case called Lister and Lane some time ago, it was said that if the works result in the subject matter being a different thing from that which previously existed, then the works are probably improvements and therefore are not caught by the general obligation to repair. And that has been followed in a number of cases. One of the best examples of that of fairly recent times, or certainly more recent than Lister and Lane, is this McDougall case, where the local authority were obliged to repair prefabricated houses. They suffered from constant ingress of water that caused damage. So there you have it. There wasn't just water going in, the water was causing damage. So there was a physical deterioration. Temporary repairs were carried out from time to time, but there was a time when the local authority carried out major works to remedy the problem once and for all. And the core issue is whether the works were repairs. If they were, then Section 32 of the Landlord and Tenant Act 1985 applied, and the local authority had to decorate the houses for the tenants which had been damaged by the war. But if the works weren't repairs, then Section 32 played no part. So it was a little topsy-turvy. In the Court of Appeal, Lord Justice Mustill said, well, it's pointless to try and attempt a complete reconciliation of all the authorities. That's what I would say. And whatever formula that one uses to identify an improvement on any view, the works in the McDougall case was an improvement. But the judge tentatively suggested the following three elements might be relevant to the question of whether works constitute improvements or repairs. And his first is whether the alterations went to the whole or substantially the whole of the structure or only to a subsidiary point. Well, there were major works of the structures of these houses. And remember, these observations were made in the context of the works that were carried out to houses in that case. Whether the effect of the alteration was to produce a building of a wholly different character from that which had been let. What was the cost of the works in relation to the previous value of the building, and what was their effect on the value and the lifestyle of the building? So that's the sort of test that one can apply to determine whether works are repairs or whether they are something other than repairs, namely alterations. The judge made it clear in this case, and I've set out the relevant section of his judgment in the paper, that all repairs, properly so called, inevitably improve an element or involve an element of renewal and improvement. So one has to bear that in mind. As to the works that are necessary to comply with the covenant, I deal with this in the final paper very briefly, but the starting point is a matter for the covenantor to choose the method of repair. So in the McDougall case, it may well be that if the local authority had carried out some lesser works, then they would have been repairs, and therefore the local authority would have had to have made good decorative damage under section 32. And it's a matter of fact and degree on the facts of each case, whether works constitute repairs or not. And I'm afraid you'll find that the expression, one might say glib expression, it's a matter of fact and degree, appears very frequently in the context of dilapidations. It's not an obligation on the covenantor to replicate exactly what existed when carrying out repairs. So, and a repair may well involve installing something which not only differs from the original, but on any view is better. Another example arising in the context of flat roofs is that flat roofs, the surfaces of which have changed since the 80s. They're now different methods and products and materials. Change in legislation and regulations requires a better practice, more modern design, technology, and so on and so forth. Those changes do not necessarily take the works out of the realm of being a repair. However, there comes a point when a Rubicon is crossed, and if the works are so substantial as to give back, or result in giving back something entirely different, then that will be an improvement, or if not improvement, it won't be a repair. I hesitate to use the word, but it arises in this context. Cladding is the word. I've had to advise, I'm sure many of you have, since the unfortunate disaster at Grenfell, on cladding issues to varying degrees, and putting aside statutory intervention, if there is any, and funds and so on and so forth. My advice has been based upon the principles that you've seen, or I've spoken to this afternoon, that unless there's been some physical deterioration in the condition of cladding, the fact that it is not of a very high standard in terms of fireproofing does not mean that it has to be replaced under a general covenant to repair. Now, the obligation in respect of defective cladding post Grenfell may be different if the covenant said keep in a good condition. See the Credit Suisse case. Can it be said that a building clad in material which is combustible to a dangerous degree is in a good condition? Query, that's the debate. But prima facie, the cladding, if in a good physical condition, will not be caught by an obligation to repair. The final element of the first paper is inherent defects. It was once thought that an obligation to repair didn't oblige the covenantor to remedy an inherent defect in design or construction which caused deterioration to the subject matter of the covenant. But that's not the law. And the starting point for that is the Ravensself Properties case, decided back in 1980 by Mr. Justice Forbes. In that case, a building was covered in Portland stone, and there was a differential in expansion between the stone and that to which it was attached. The stone was falling off. the problem had to be solved, or could be solved, by expansion joints being inserted and so on and so forth. And the covenantor took issue with the cost of that, saying that it was not a repair, but an improvement. And in a worthwhile judgment, Mr. Justice Forbes disagreed with that it, in order to maintain the building in accordance with the covenant, in order to repair it, it necessitated the insertion of these expansion bolt joints, and therefore was caught by the general obligation to repair. So it's too easy for someone to say, well, I don't have to do this, or I'm not paying for this because that's work to incur an inherent defect. The Brew Brothers and Snacks case relied upon in Ravenscroft also supports that proposition. Again, it says one looks at the condition of the premises at the date of lease, the prospective life of the present premises, the length of the lease, and then make a decision as to whether the works go beyond repair and are improvement of an inherent defect. This principle was considered very recently in a case which I don't address in the slides for reasons which I can't remember, but it's dealt with in the notes. It's called the City of London against various leaseholders of Great Arthur House. It was decided in March this year. The building contained a number of flats. The tenants covenanted to pay the local authority the cost of carrying out specified repairs, and they were defined to include to keep the the structure and exterior of the building in good repair, not amounting to making good of structural defects. And the question, the landlord undertook a scheme to the structure and exterior, and put the cost. It was £8 million. Passed the cost on to the tenants, £72,000 a pop for each of the tenants. You might imagine that these were former local authority housing, and that may say something about the economic status of the tenants, maybe not. But anyway, they didn't like that. And the Court of Appeal held that this work went far beyond what was necessary to repair the building. Complete removal of the existing curtain walls, installation of a new one, strengthening making good the frame, new sliding windows, and so on and so forth. And relying upon the Ravenscroft, McDougall, Quick, and the Post Office case, they said that these were not these amounted to making good structural defects, and therefore were not within the specified repairs which the tenants covenanted to pay for. So that's a brief run through of the nature of the obligation. The second element of the paper, forgive me, I call compliance. And speaking to that, the first point I wish to make, what does the time for compliance, or when does the time for compliance arise? Well, I make a preliminary point that during the term, it's not normally of importance, because the tenant's got the lease for a long time. It doesn't matter the landlord is out of repair. Come the end of the term, the tenant's under an obligation to yield up and repair, and any repair issues can be dealt with at that stage. Of course, that might not always be the case. If the landlord wants to forfeit for whatever reason during the course of the term, the landlord has to ensure that by the time, or at the time that 146 notice is served, the tenant is out of repair. The condition of the premises might be relevant if there's an option exercisable by the tenant to renew, or in a current climate to break. I've done a number of cases in the last 2 years, fighting tooth and nail as to whether an option to break has been properly exercised, both for landlords and for tenants. So it might be important to know at what date the tenant is in breach of his or her covenant. And of course, for rent reviews, it might be important to know when a tenant was in breach of a repairing obligation. But putting that aside, the general proposition is that there's a continuing duty on the tenant to repair during the term. So if there's a deterioration in the physical condition, immediately the tenant is obliged to repair. There's no notice required for the landlord. You remember the other way around, it's rather different. The landlord covenants to repair part of the demised premises. The liability to repair doesn't arrive until the landlord has notice of the want of repair. That's not the position in respect of the demised premises where the tenant covenants repair. And as I say, the British Telecom case and Sun Life supports the proposition that the immediate obligation to repair arises once there has been a deterioration from the previous physical condition. What is the standard of the repair? Well, in the first instance, it's a matter of construction, as we dealt with a little while ago. The covenant may well make specific provision, but under a general obligation to repair, the standard of repair is that which is demanded having regard to the age and the character and the location of the demised premises. And that standard must be reasonably fit for the occupation of a reasonably minded tenant of the class who would likely take the premises. And in Proudfoot and Hart, the point was made that a house in Belgravia may well have to be maintained to a higher standard than a house in Spitalfield. The house in Proudfoot and Hart was in Caversham Road in Kentish Town, where I used to live as a small boy. So although I wasn't alive in 1890, it just seems like that. But that's the starting point, that it's the age, character, and location of the premises has a significant, if not a determinative input on the standard of repair that needs to be carried out. The classic example would be, for example, in tiling. If one has a very high-end set of premises, a headquarters office block or a substantial and expensive dwelling, then sticking tiles that are nearly the same color as the existing tiles probably doesn't cut the mustard. Whereas in a lesser building, school perhaps, nearly the same colored tiles would probably do. The reasonably minded tenant of the class who would like to take the premises is not determined by the market. This is a hypothetical tenant, but who is it that takes premises of the nature of the subject premises? I can give you an example fairly close to home. Say a suite of basement rooms in Lincoln's Inn. A reasonably minded tenant of the class likely to take the premises are barristers. I'm not saying they necessarily like to have tatty accommodation, but compared to, say, a big city firm of solicitors or a bank in the city, the standard of repair may well be very different because of those obligations. So the standard is age, character, and location, and it's the reasonable tenant is the criterion. The substantial repair, that's the obligation. It's not perfect repair. The case on the screen, Simmons and Dresden, is a case of mine decided back in 2004 involving a house in Doughty Street, which had been demised to a firm of accountants and then sublet to a set of barristers' chambers, not mine. And at the end of the term, the landlord, who was a solicitor, claimed damages from the tenants, saying that the building was out of repair. His claim for damages failed entirely, notwithstanding that the judge found that there were wants of repair, but because of the Section 18 requirements or the defence, which we'll talk about in the next paper, or not the next paper, the next webinar, please come along, meant that they recovered no damage at all. But the words of Judge Seymour, the official referee, that I quote are of value, I suggest. The covenant had talked about substantial repair, and he said that what was required, that in its essential, but not necessarily in each and every minute detail, the premises would be repaired, renewed, cleansed, and kept. I don't think that that is a standard which, in practical terms, is different from the standard of such repairs as having regards to the age, character, and location of the house. So what the judge was saying there, that although the covenant did talk about substantial repairs, that didn't impact on the standard that was required under a general covenant to repair. And he accepted my submission that the test was the age, character, and location of the house. So, for example, in that particular case, when the premises were demised, some of the larger rooms had silk wallpaper in them. When the tenants carried out the final dilapidations, they didn't replace the silk wallpaper, but papered the wall with perfectly adequate wallpaper that was painted over to make very clean, sharp rooms that could be used as accountants' offices or barristers' chambers or offices for a firm of solicitors. And having regard to the age and the character and the location of the house, and more significantly, the reasonably minded class of tenant who would take it, namely office users, essentially, newly papered walls with beige paint on it, nicely done to a high standard, was sufficient in order to satisfy the obligation on the tenant to repair. So the compliance with the obligation is determined by the age, character, and location of the premises, and a standard that would be demanded by the reasonably minded tenant of a class likely to take the premises. That's the test, and as always, whether that standard is met is very fact sensitive. In the last few minutes that we've got, I'll deal with the breaches of the tenant's repairing obligations. I've addressed this in a sort of inverted way, namely what it is that the tenant has to do, and if the tenant doesn't do this, then he or she will be in breach. What work is required? Well, the work that's required is that which is a matter of professional judgment. The work the paying party selects must be such as a competent, careful surveyor or other appropriate professional person would advise as being appropriate. And that's Mr. Justice Newberger in the Gibson investment case. So that's a good starting point in a case other than the most simple. One doesn't need a professional to advise that a cracked or broken window needs to be replaced by another piece of glass. Then if one has taken professional advice and provided that advice is one that a reasonable professional could give, then that will be sufficient work to satisfy. Now, the work must bring the premises up to the standard that we've just discussed, but how that is achieved, the mechanics, if you will, of achieving that standard is a matter for the covenantor. The works mustn't be futile. There's no point carrying out works that will fail within a disproportionately short time. I quote from the Gibson case on the slide. Not futile. In some circumstances, performance of the covenant is not achieved if the work proposed will not remedy the defects once and for all. It's a bit of an overlap there with the patch or replace type debate that we've spoken of. And I've given an example by reference to the Stent case about wooden front doors, where the front doors were replaced with self-sealing metal or plastic doors, which did the job long term. Works must be reasonably necessary, not just desirable or convenient. Now, this is quite an interesting area, because when landlords, say at the end of the term, get their mitts back on the premises, they always want to improve the premises. The lighting needs to be better, the facilities for IT have to be better, and so on and so forth. So it's not unheard of, believe it or not, for landlords to lump into the terminal schedule of dilapidations works to bring the premises up to the modern standard, not the standard that's required by the lease. That's not caught by the tenant's obligation to repair. When carrying out repairs, it might be convenient or desirable, for example, and this is the Euston Centre case, to rip out the asbestos that's there, even if there's no statutory obligation to do so, because we've all gone off asbestos, unless you're Donald Trump, of course. And that cost of removing that that's asbestos, and it would not be caught by the tenant's obligation to repair, and therefore that's not a liability that can be passed on to the tenant. More than one acceptable means of repairing, as I've touched upon before, ultimately, or in the first instance rather, it's in a matter for the covenantor, and where there are several possible methods of repair, each of which would comply, the choice is a matter for the person who's covenanting. And particularly in the context of tenants, it'll usually be the cheapest option that can be got away with, and there's nothing wrong with that. So it's not for the landlord to second guess the tenant and say, well, I'd prefer it, or it would be better to adopt means X if means Y will achieve the standard that's required by the covenant in the lease. And that's one of the uncontroversial propositions that Lord Justice Lewison describes in paragraph 14 of his judgment in the Waller case, which I've mentioned more than once. Replacement or piecemeal repair, again, we've touched upon this more than once in the earlier discussion. The basic principle, it was the covenantor will only be liable to replace an item if a patch repair is not a reasonable or sensible solution, the burden of proof being on the party who asserts a replacement is necessary. And coming back to where we started with this this analysis, if the covenantor is advised sensibly by a reasonably competent and experienced building surveyor or other professional that a repair will suffice and maintain the condition of repair for an acceptable period of time, then that can't be second guessed, even if another reasonable professional would have chosen the replacement route. Replacing like with like, the covenantor may be obliged to or entitled to install something completely different from the original, as I've mentioned before, to comply with legislation or regulations, comply with good practice, prevent the original defect from reoccurring, or take advantage of modern methods and material, or because that is what a sensible and practical surveyor would advise. But we've got to be a little careful about that. I repeat, the temptation, particularly on the case of landlords, to improve is almost irresistible. In this Kreska case in the London Borough of Hammersmith, there was an underfloor heating system which was defective. The covenantor wanted to abandon that entirely and install wall-mounted electric heaters around the building. The tenant, I think it was the tenant, objected to all of this for reasons that are obvious, because the wall-mounted stuff ate into the let space, whereas the underfloor space didn't. And the Court of Appeal held that it wasn't impractical or impossible to repair the underfloor heating. It was just that it would cost more, and that wasn't a reason for adopting a completely different method of warming or heating the demised premises, and therefore was not works that satisfied the landlord's obligation in respect of the tenant. Again, a case I was involved in is probably about two and a half years ago, involving a very large block of flats up in Highgate, if I was being nice to them, or Archway if I wasn't, where a manager was appointed. There was a schism between the tenants, and the manager took it upon himself to replace the entire heating and hot water system for these 100-odd flats. I can't remember whether it's a very large block, with a completely new system. And the court decided, in a very bad-tempered piece of litigation, that the works that carried out simply weren't within the covenant at all, and therefore couldn't recover a penny piece from the tenants under the service charge provisions of the lease. There were other issues, but the point there is it's not enough, as the manager said in this case, that the system I'm putting in is going to be really good and it's reasonably priced, and in many respects will be better. It simply wasn't a repair within the obligation placed on the manager in the shoes of the delinquent landlord. So that's a quick run through. At the end of the this third paper, I've set out, because I couldn't resist it, the summary in paragraph 14 of Mr. Lord Justice Lewison's judgment in the Waller case, and it summarizes many of the principles that we've looked at this afternoon. And I set it out in the paper together with the authorities he relies upon. But in summary, they are that the concept of repair takes as its starting point the proposition that that which is to be repaired is in a physical condition worse than it was at some other time, where the deterioration is the product of an inherent defect. The carrying out of the works to eradicate that defects may still be a repair. Prophylactic measures taken to avoid the recurrence of the deterioration may also be repair. In principle, where there's a choice of methods of carrying out repair, the choice is that of the covenantor, provided that the choice is a reasonable one. At common law, there's no, his words, bright line division between what is a repair and what is an improvement. And finally, the use of better materials or the carrying out of additional work required by building regulations or in order to conform with good practice does not preclude the works from being works of repair. So I repeat, the Waller case is a case very much worth spending a little time reading. That's all I've got to speak to this afternoon. I repeat, a fuller treatment of the principles and issues that I've addressed will be found in the papers, which will be distributed to all the delegates. Let me thank you again for spending some of your valuable time with me this afternoon. Don't forget, if you have some questions, just email me and make a note in your diaries for the 11th of November and the 9th of December for the next two installments of my treatment of the law of dilapidations. I wish you all a good afternoon.